Well, good morning again, colleagues, and thank you for joining us. As I mentioned earlier, we're being joined by members of the Monitoring Committee to participate in a hearing on regulating foreign influence, best practices and European standards. I remind colleagues that the hearing is open to the public, it is being recorded, and that it will be transmitted on the Assembly's YouTube channel later. And at this point, could I pass over to Zander as chair of the Monitoring Committee to preside during this hearing. Thank you, Zander.
Thank you so much, and very good morning to everyone. I'm happy to see quite full room for this very important event co-organized by two committees. And dear colleagues, indeed the mandate of the Monitoring Committee is to assess the honoring of obligations incumbent on all member states under Article 3 of the statute, which means so the compliance with the principles of pluralist democracy, the rule of law, and respect for human rights. So when carrying out this task, we have expressed on many occasions our concerns regarding different so-called foreign agents laws already in force or under consideration in several countries. At the same time, we are fully aware of the destabilizing effect of ill-interested foreign interference in domestic political debate. And there are definitely a need also to protect our democracies, to protect European democracies from malicious interferences. So regulating foreign influence, and in particular its transparency, is necessary in our times, but it should be done with respect for countries' obligations and without damaging fundamental rights and freedoms. And we see good examples where it is possible, and it is clearly that we can cut clear between good practice and the ones that are violating our principles and values. So as lawmakers in our respective parliaments, we should have a clear vision which measures comply with democratic standards and which violate them. This is where our distinguished speakers can provide a precious input, and I'm sure that we will have very interesting and fruitful discussion and will be able to draw important conclusions. So, dear members, by that it is my great pleasure to welcome our two guest speakers, Madame Veronika Bílková, Vice President of the European Commission for Democracy Through Law, so-called Venice Commission, which we cherish and mention in this house very often, and also Madame Tanya Lokshina, Associated Director, Europe and Central Asia Division, Human Rights Watch, an important aspect in this discussion. Madam Bílková, if you would be ready to start, and according to our plan, you could have floor for about 12 minutes.
Good morning. Thank you very much for the floor, and thank you very much for the kind invitation. I'm really very pleased and honored to have the opportunity to attend this meeting and to speak about foreign agent laws and the perspective of the Venice Commission. When doing so, I will build on certain general studies that the Venice Commission has issued in this respect, especially the 2015 joint guidelines on freedom of association, joint because they were adopted together with the OEC auditor, and also more specifically the 2019 report on funding of associations, which is the most detailed report published in this sphere, so I would recommend it to your attention. I would also build on some country-specific opinions related to the legislation on foreign agents that the Venice Commission has adopted over the years, especially the opinions related to the Russian Federation, Hungary, Kyrgyzstan, and most recently to Georgia. My presentation will proceed in two parts. I will first briefly introduce this legislation, that means explain the nature and also typology of these laws, And then in the second part, I will draw your attention to the elements of these laws that the Venice Commission has found problematic in the country-specific opinions that I mentioned. So I will start with the first part and general introduction of the foreign agent legislation. In the very broad sense, we can say that foreign agent laws are any laws applicable to different entities, mostly non-commercial organizations, broadcasters, social media, or individuals, who or which receive a part of their funding from abroad. This is a very broad definition, and it actually covers two very different types of entities. On the one hand, it covers entities which act at the direction or control of a foreign principles, or entities where there is a special link between them and someone from abroad, a foreign principle, and which really act under the direction or control of such a principle. Laws applicable to those entities are actually laws on lobbying. And the US FARA or the Australian FITSA are good examples of this type of legislation. Also, the EU directive, which is being negotiated at the moment, seems to be going in this direction. In my presentation, I will not focus on this first category of foreign agents laws in the broad sense. Rather, I will focus on the second category, which we can label as foreign agents laws in the narrow sense, and those are legal acts which applies to any entities just because they receive a part of their funding from abroad, even if there is no specific relationship of direction or control between them and the foreign funder. In fact, the funding can be very dispersed. It can be even quite minimal coming from abroad. They can receive a minimal portion of their funding from abroad, but they still, under some legislation, get labeled as foreign agents laws. Now, over the past 13, we can say years, several countries have adopted the legislation of this latter type. And I will mention just some examples of them, and I would like to stress not all the laws are the same in their content, and not all the laws are similarly problematic, but they fall under the same kind of scheme. So the examples of countries which have enacted such laws are Belarus, India, the Russian Federation, Israel, Egypt, Kazakhstan, Nicaragua, and then in this year, Kyrgyzstan in Georgia. You see, it's a very diverse set of countries. Some countries also adopted such laws, but then abolished them for different reasons. That was the case of Ukraine in 2014 in the latest part of the Yanukovych rule, or Hungary, which abolished the legislation after the Luxembourg court found it problematic. Now, about the content, obviously these laws are very different. Some of them simply say that foreign funding is not allowed, so they prohibit foreign funding. This is, however, a minority of laws. That's, for instance, the case in Egypt. Most of the laws regulate foreign funding, so they don't prohibit it, they allow it, but they regulate it in the sense that they introduce certain specific elements, and these elements are normally fourfold. So these laws normally rely on four main pillars. The first pillar is the introduction of a certain definition for these entities and also of a certain label. The best known label, obviously, is a foreign agent, but there can be other labels. For instance, entities pursuing the interests of a foreign power or something similar. What is common is that these labels are not neutral. They normally have negative, pejorative connotations in the specific linguistic community. So this is the first element. The second element, these laws introduce various additional obligations for these entities. The obligation to register in a specific register, the obligation to present and submit specific reports to the state authorities, the obligation to disclose to the public various information, sometimes even very internal and personal information, and sometimes also additional obligations or additional prohibitions. So, for instance, in some countries, entities labeled as foreign agents cannot run in the elections or play any role with respect to the election. So this is the second element. The third element are powers of certain state bodies, often, for instance, the Ministry of Justice, which are strengthened with respect to these entities. So state authorities get specific powers, which are usually very broad, vaguely defined with respect to those entities. And they often encompass the obligation of enhanced monitoring, checking, regular controls. And the last element are sanctions. So there are different criminal or administrative sanctions introduced specifically for the failure to abide by this legislation. And not always there is a strong involvement of courts. Very often it's left to administrative bodies to decide on these sanctions. That brings me to the second part of my presentation, where I would like to focus on the problematic elements of these laws. And obviously I'm speaking very generally, so I will not mention specific examples, but it's based on the analysis that we've made in the Venice Commission. The legal analysis starts from the legal standards, which are mainly those contained in the European Convention of Human Rights for the Council of Europe member states, and in the ICCPR, the International Covenant on Civil and Political Rights for the non-European countries. And the most relevant legal standards are those related to the right to freedom of association, right to freedom of expression, and the right to privacy. Also, sometimes the prohibition of discrimination is at stake. Now, these rights are not absolute. They can be limited. And sometimes the limitation, if they are done properly, can be lawful. That means that prohibiting foreign funding per se is not necessarily unlawful, but such restrictions need to meet the three-part test which is foreseen by all human rights instruments. That means the test of legality, legitimacy, and necessity/proportionality. And unfortunately, those foreign agents laws that the Venice Commission has had the opportunity to assess so far have mostly failed in all the three parts of this test. So let me explain. The first element is the element of legality. Under this element, the restrictions imposed on foreign funding needs to be foreseen by law. That means the law needs to exist, which is normally the case, but also the law needs to be specific, precise enough, without vague formulation, without imprecise formulation, and it needs to grant limited discretion to state organs. In reality, it's the other way around. There is a law, but it's very vague, contains very general, undefined formulations, such as foreign influence, political activities, etc. And there is normally very broad discretion granted to state organs, as I already mentioned. So the principle of legality, or the condition of legality, is very often not met. The same applies to the second condition, the condition of legitimacy. Under this condition, the legislation, the restriction imposed on foreign funding, needs to pursue one of the legitimate aims explicitly mentioned in the human rights instruments, which is, for instance, the protection of national security or the protection of public order. Now, in most cases, other so-called aims or alleged aims are put forward by the governments. The most common one probably is the aim of transparency, which, however, in itself does not feature in human rights instruments. Moreover, in many cases, there might be a doubt whether transparency, whatever it means, is the true aim of this legislation, or whether there is some ulterior purpose behind, such as, for instance, silencing certain entities in the society. So the condition of legitimacy is often problematic as well, and is not met. Finally, the element of necessity and proportionality. Under this, it's important to establish that there is a pressing social need to adopt such a legislation. To establish that, there should be some evaluation carried out, but this is rarely the case. Normally, it's just presumed that these entities, if they received even a tiny amount of money from abroad, serve foreign purpose. So it's more presumed than established. Moreover, it also needs to be established that the measure, the restriction which is adopted, is the least intrusive one, and that it does more good than harm, both to the entities concerned and to the society at large. However, what we see is that normally this legislation does more harm than good, more bad than good, because it's clearly destructive for these entities. It's also clearly destructive for the society as such, So just to conclude, 4 points that I would like to stress. The first one is that The foreign agents laws, which have recently been adopted in various countries, are different from the laws on lobbying, such as the US FARA. That's for sure. Different purposes, different scheme. That's the first issue. The second element, many of those foreign agent laws, and obviously the Venice Commission has not assessed all of them, fail to meet the test of legitimate restrictions of human rights, the test of legality, legitimacy, necessity, and proportionality, and as such are not compatible with European and international standards. The third element, these foreign agents laws actually establish what I describe as a trap model for entities concerned by them. These entities are doomed whether they comply with the laws or not. If they do, then their reputation will be tarnished because they will have this label on them. They will most probably not be able to abide by all these obligations, and they will simply not be able to operate. However, if they don't register, they will also not be able to operate because they will be ruined by the fines or sometimes by the dissolution. So it's a trap model. There is no good way out of it for these entities. And the last 4 point, the foreign agents laws are destructive not only for the entities targeted by them, but also for the societies, because they impoverish the public debate. They have a chilling effect on the situation in the civil society because they very often target civil society or media, and they are simply destructive if designed in the way I describe to a democratic society as such. Thank you very much for your attention. I hope I have not been too long, and I would be very happy to take any questions you might have later on.
Thank you so much, Madam Bílková. And now it's Madam Lokshina. You also have about 12 minutes, please.
Thank you very much, Madam Chairperson. And by way of introduction, I cannot but reiterate what you said in your opening statement and what Ms. Bílková has just emphasized. It would be indeed reasonable to say that governments can have systems in place to identify when specific actors are paid to promote the interests of another government. Tracking the influence of money in politics has a legitimate aim to promote democracy. However, the autocrats usurp and pervert it for non-democratic purposes, which makes it all the more important for governments who are using foreign influence tracking systems to make sure that those measures are absolutely necessary, narrowly drawn as opposed to broad, and closely monitored by an independent body to identify and address any pernicious impact or chilling effect on civil society. Also, most unfortunately, one cannot help but emphasize that such measures in democratic countries, adopted in good faith, are cynically used by autocratic governments to justify their own abusive foreign agents law, which definitely do not meet the three-part test that Ms. Bílková was referring to. I was asked specifically to speak about Russia's foreign agent legislation. Russia is obviously no longer a member of the Council of Europe, but the way that legislation evolved and the way that legislation is being implemented by the Russian government against civil society is a stark example of the damage that a foreign agent law, adoptive for repressive purposes, could do. So Russian foreign agent legislation is a signature weapon in the government's anti-rights arsenal. Aimed at stifling civil society, it seeks to smear anyone or anything that is independent or critical of the government as foreign and alien, and therefore suspicious, subversive, or even treacherous. Enacted first in 2012 and repeatedly boosted since, Russia's foreign agent provisions have been used to harass a wide range of activists and critical voices, and as a pretext for shutting down some of the country's leading human rights organizations. Every few years, amendments harshened and expanded the toxic piece of legislation. For example, in 2014, Parliament adopted amendments to authorize the Justice Ministry to proactively and extrajudicially designate non-governmental organizations as foreign agents without their consent. In 2017, Russian Parliament adopted an additional piece of legislation seemingly targeting certain foreign media as foreign agent media. And then, 2 years later, additional amendments to the law expanded that category to include individuals, including Russian nationals, and entities, including Russian non-governmental organizations. Laws adopted in 2020 and 2021 drastically widened the scope of foreign agents to include individuals and unregistered civil society groups, and expanded the definition of funding sources that could trigger a foreign agent designation. It also expanded the inspection regime and introduced new, particularly problematic labeling requirements. Then in 2022, a new law, which is part of this whole main bulk of foreign agent legislation, created a consolidated and drastically broad definition of foreign agent. Today in Russia, it could be any person, Russian or foreign, any legal entity, either domestic or international, any group, possibly unregistered, that receives foreign support. And foreign support is defined so broadly that it could include, for example, a travel reimbursement for a representative of a non-government organization who attended a training overseas, or the kind of a meeting that I'm present at here and now, right? So any amount of foreign money does not necessarily have to be grant money, anything at all. Now, what are the actual restrictions on foreign agents? The 2022 law, among other things, imposed such restrictions that they basically exclude foreign agents from public life. These include bans on civil service, bans on access to official secrets, participating in electoral commissions, participating in political parties, donating to political parties, running for public office, holding public service positions, participating in advisory or expert bodies that provide recommendations to the government, participating in public commissions that monitor places of detention, state or public environmental impact assessments, independent anti-corruption expertise, draft law expertise, election campaigns, donating to election campaigns, and so on and so forth. So excluded from pretty much everything. Foreign agents are also banned from organizing public assemblies or supporting public assemblies through donations, teaching, conducting or organizing any sorts of educational activities for children, or producing information materials for children. They are banned from participating in procurement tenders, receiving state grants or other financial support, including for creative work, and benefiting from simplified account or taxation procedures. Their funds cannot be insured, and they cannot operate critical information infrastructure, including telecommunications network. The legislation also explicitly stipulated that violation of the foreign agents regulation by foreigners or stateless persons requires their deportation from Russia. A large number of civic groups and activists, including those that work on human rights, the environment, election monitoring, and anti-corruption, have been designated foreign agents by the Russian government. And the provisions of the foreign agents legislation allows authorities to bar them from their work and prevent them from directly engaging with the government on these critical issues, or engaging with the society for that matter. The ban on producing information materials for children resulted, for example, in several bookstores across Russia putting books whose authors were designated as foreign agents into special wrappings and marking them as adult content, or taking them off the shelves and just making them completely unavailable. In 2023, recently, penalties also extended to third parties who provide unspecified assistance to people designated as foreign agents. Sanctions for non-compliance with foreign agent legislation in Russia start with very hefty fines, but also include up to 6 years imprisonment for malicious incompliance. Now, the Ministry of Justice used to maintain several foreign agent registers for NGOs, for unregistered public associations, for media foreign agents, and for physical persons foreign agents. As of spring 2024, they merged those registers into one, and at this time, this register includes well over 800 persons and entities. Among other information, the registry contains data about dates of birth, speaking of the right to privacy, taxpayer numbers, personalized pension insurance numbers, which is similar to, say, social security numbers in other countries, for individual foreign agents, and registration numbers, lists of members, web addresses, locations of organizations, of public associations, which is a huge security issue, obviously, in a country like Russia, and so on and so forth. Now, bylaws that were developed by the Justice Ministry in 2022 list the following categories to be included in the foreign agent registry. Individuals intending to act as foreign agents, whatever that means. Foreign nationals residing abroad who intend to act as foreign agents upon arrival to Russia. Foreign journalists accredited in Russia and conducting foreign agent activities not related to journalistic activities. Legal entities incorporated in Russia by foreign agents who failed to apply to be added to the official registry. In addition to the foreign agents registry, Russia now has a separate registry for persons and entities, quote unquote, affiliated with foreign agents. Again, whatever that means. Presently, this registry is not even available in public domain, but according to Russia's Justice Ministry, at the end of 2022, it contained information about 861 individuals affiliated with foreign agents. So that number now should be much higher than that. Since Russia's full-scale invasion of Ukraine, foreign agent designations have drastically increased, and the list includes numerous well-known public figures such as opposition politicians, journalists, entertainers, bloggers, writers, and other individuals who were vocal in their opposition to the war. Now, just by way of comparison, between February 2022 and February 2024, the number of foreign agents in the Russian Federation actually doubled, right? When commenting on yet another harmful expansion of this foreign agent legislation, and again, like I said, the initial law was adopted in 2012, and then it just kept getting boosted and boosted and boosted. A very prominent Russian lawyer and a member of the Moscow-Helsinki group, a leading human rights organization, which incidentally got shut down by the government over incompliance with foreign agents law, Ilya Shablinsky said the following: Russian authorities essentially aim to turn foreign agents into a caste of untouchables, or create for them something like a virtual leper colony. Honestly, I could not but agree with this eloquent assessment. Anyway, pressed for time. In conclusion, I would like to say the following. When the Russian law was getting adopted in 2012, at Human Rights Watch, we knew it would have a stifling effect on civil society. And our Russian partners, Russian human rights organizations, were of course appalled by those developments. The proponents of the law in the Russian parliament and the government kept saying loud and clear, oh, this is not going to have any chilling effect on civil society. We are doing this solely for the purposes of ensuring transparency. That was the opening rhetoric, and a very prominent rhetoric by the government. However, it became clear very quickly that this is not about transparency at all. This is indeed about silencing critical voices. And the horrendous reality which I described for you right now, it did not arrive in one day. Because yes, in the beginning, it took the government about 1 year. The implementation was not that quick to designate 5 specific organizations as foreign agents. And those organizations were somehow deemed by the government to have something to do with public protests that were very active in Russia, peaceful public protests in 2011-2012, especially around Vladimir Putin returning to the Kremlin. What made the government think that those organizations were involved with the protests? Well, like several of them, for example, had hotlines for persons arbitrarily detained during the protest and beaten by the police. Then those organizations went to courts, and they spent a lot of money, a lot of effort, and a lot of time, which they did not have, on litigating their own cases, and they lost their own cases. So they ended up on the list. Then the Ministry of Justice gets the powers to designate proactively, and dozens of prominent human rights organizations, environmentalist groups, and whatnot get on the list. The labeling requirement is horrendous. Organizations and then later on individuals have to label each and every their publication or even a document, say a letter of inquiry they send to governmental authorities, as authored by a foreign agent, right? So it spreads and spreads and spreads and results in a situation when the government is not acting in good faith, that civil society simply cannot operate any longer. And this is a great threat that has to be kept in mind. Thank you.
Thank you, Madam Lokshina, and indeed, thank you to both of our experts who provided a great start for our discussion. And so now I would like to open the floor for your questions, remarks, and interventions. Yes, Mr. Hispan goes first, please.
Thank you, Chairman, Mr. Chairman. I want to ask one question about the standards that you have set. Which are the most clear cases that you have a study of Russian interference to set those standards. So which are those clear examples of how Russia has acted? So, and after knowing what has done, set those standards. Thank you.
Apologies if I understood the question correctly. It's about how Russia failed the three-tier test, right? No.
How Russia interfered in Western countries as a foreign influence.
How Russia interfered in Western countries as a foreign influence. Well, I mean, that was not precisely the topic of my presentation, but while, yes, indeed, Russian propagandist media has been extremely active in attempting to influence public opinion and policies in different countries across Europe. And it's also no secret at all that the Russian authorities have been supporting far-right parties in Europe. So when we are talking about foreign influence, like I said in the opening of my presentation, tracking foreign influence and harmful foreign influence in particular is a legitimate aim in democratic society. But it does not necessarily need to be done through foreign agent legislation. There are different means to do that. And I would also want to refer to the hearings on the European Union Foreign Influence Directive, which took place in Brussels at the EU this past Tuesday on the 25th of June, where the delegation of Germany said specifically that the European Union should not be adopting the directive because it gives such a good excuse to authoritarian governments to justify their own legislation. And I would say that this particular approach is understandable. It is important to on the side of caution in those situations.
Thank you. I wonder if I could ask Ms. Bílková about the recent opinion from the Venice Commission on the Georgian legislation. One of the features of that which you addressed in the opinion concerned the legislative process that had been adopted in April 2024, which, amongst other things, had involved a third reading of the proposed legislation, which was not even made public. And are such deficits in the legislative process a feature that also arises with regard to the authoritarian regimes seeking to introduce this sort of legislation?
Thank you very much for this question. Before I address it, I would like to express my satisfaction as to how well the two presentations actually complemented each other. We did not coordinate, but Mrs. Lokshina in her presentation actually documented on a specific case exactly the problematic phenomena that I was describing in general. So I was really not happy to hear it, obviously, but pleased to see a concrete case of all these phenomena. Now, going to this issue, it is a standard practice of the Venice Commission when we assess a piece of legislation that we focus not only on the substance, the content of this piece of legislation, but also on the legislative process, because obviously the legislative process is very important for the outcome and also for the general standards of the rule of law, because obviously only a legal act which is adopted in a regular and fair legislative process is a good piece of legislation. Now, we did this also in the opinions related to the foreign agents, and unsurprisingly, in many of them, we identified, though not only there, obviously, but also there, we identified huge failures. So very often, these pieces of legislation, first of all, are very rushed ones. That means they are adopted in very short terms. They are important pieces of legislation, but they can be adopted within days, maximally weeks, which is not a very standard procedure. That's one element. The second element, which is frequently missing, is any broader public consultation. It is a recommendation of the Venice Commission. It's a good practice, and we spoke about good practice at the beginning. So it's a good practice that whenever the state adopts a legislation directed to a particular group or sets of entities, then these entities are consulted, have an opportunity to say what they think about this piece of legislation. Such public consultation is regularly missing, as is a broader public consultation, not only with the entities targeted by the legislation, but with the general public. So this is the second phenomenon, or the second element, which is often present or absent, rather. And there are typically other procedural failures. So yes, it's not only about the substance, it's also about the procedure, which tends to be problematic.
Thank you for that. Could I invite other colleagues to come forward? Mr. Mikanadze.
Thank you, Chair. Good morning to everyone. First of all, I would like to express gratitude for organizing this important discussion, as well as, of course, we have a very long-standing and very constructive cooperation with the Venice Commission, and I would like to express my appreciation for this cooperation. First of all, I assume that we all agree that transparency is something which is valuable and which is important for everyone. When we focus on the attention to the NGO sector transparency, here we can say that I will make some kind of a quote from the ECJ Grand Chamber decision regarding the Hungarian law from 18 June 2020, paragraph 79, saying that NGOs from their goals and funding may have important influence on public life and public debates. Accordingly, transparency of the finances of these organizations constitute high interest of the society, which is obvious and which is, I think, acceptable for everyone. Every country in this challenging period is trying to strengthen and protect its sovereignty and strengthen the capacity of this sovereignty, especially when we have those challenges which are threatening on a daily basis. If we take an example of Georgia, and if I have 2 minutes to just give my short overview, everyone here is aware that until now, more than 20% of Georgian territories are still occupied by Russian Federation. We have Russian troops illegally presented on our soil, just 40 kilometers away from the capital. And we are facing threats on a daily basis. Disinformation and different kind of activities, soft powers are playing important role. I can bring you one very simple example. When in 2022, Georgia really unfairly was not granted EU candidacy status, Russia immediately started using its soft power, disseminating information among the society that Europe has abandoned Georgia and that you have no possibility to go somewhere, and so on and so on. And in many other cases, for instance, when we say why Georgia adopted recently this law, and although I respect everyone present here, I want to disagree with some statements. First of all, that Lord Keane made a statement about that some information was not displaced timely or generally, which is not true. I can take all responsibility for this, that everything was fully transformed and presented to the society, and all legislation has been discussed in the presence of the NGO sector representatives. The draft bill has been initiated on 4th April, and finally it was adopted on 28th of May. Almost 2 months it was under discussions, and all 3 hearings with all 3 committee hearings and the plenary hearings took place. Also, I cannot agree with the statement of the Venice Commission in its opinion, saying that this law was not needed because other laws were regulating the situation. I can assure you that if other laws could regulate this issue, there would not be an issue of having and adopting additional law. And now I will go why this was the decision was taken. Recently, during the last 2 years, why we have not adopted this law some years ago. Just recently, during the last 2 years, we have found out that some of opposition parties started establishing new NGOs, which were getting funding from different sources. And we found out that this is an indirect funding of political parties, which is prohibited in my country, and I assume in your countries this is the same situation, that from above funding should not be provided to the political groups in the country. Therefore, the transparency issue became an important point. And Ms. Bílková has mentioned about FARA legislation. A year ago, when our partner party has initiated the same draft bill, and it was criticized by the NGO sector, by international organizations, you know what they have done? They have just translated FARA law directly, word in Georgian, and made another initiative. And you know what was the reaction? Anyway, it was called so-called Russian law, no matter it was FARA law or not. So in that regard, I mean, like, I want to assure you that Georgia is very much committed to European values and to strengthen its capacity. But when it comes to the sovereignty, when we see those threats, which are on a daily basis, when we see that there are some possibilities of external influence to the internal situation, especially that it is just 4 months before the upcoming parliamentary elections. So therefore, this law is not something that government was demanding. I can assure you that the survey which was conducted made possible to understand that the majority of the population was in support of this law. And political parties, as I said, have established their linked NGOs. Some of them did in a way that they called the NGOs in the same way as the political parties are. At the same time, I want to highlight that this law yet has not entered into force. So we are now discussing the issue about the law, which will be entering into force a month after, at the end of July. So without knowing any results. But I understand that you are making some parallels with other countries, but I can assure you that Georgia will follow the law. And also one last point, and I will finish here, that Georgian law, Article 1, Paragraph 2, provides guarantee for any organization which will be under this law, saying that this law shall not restrict the activities of an entity registered under this law, which guarantees that even somebody under this law breaches some paragraphs of this law, there will be no possibility to frozen, stop, cancel, or put on hold the activities of the organization. And this law covers only legal entities. It does not cover individuals, and the sanctions are only fines, no criminal sanctions against anyone. Thank you.
Thank you, Mr. Mechanadze. That was barely a question, but could I invite Ms. Bílková to respond with any comments she has in light of that exposition from the perspective of Georgia?
Thank you very much for the floor again. I was happy to hear that Georgia was still committed to all the values and standards that we discussed, and also that you appreciated the cooperation with the Venice Commission, it's good to hear it again explicitly, and it's obviously also varies the other way. Georgia has been among the most common clients of the Venice Commission, and the Venice Commission obviously hopes that the cooperation will continue, though in the preparation of this opinion it was not always so obvious, and in its presentation the Venice Commission expressed its view on this legislation in the opinion, which is public, so I'm not sure whether it makes sense to go very much into the details of this piece of legislation. Anyway, I would then go back to my three-part test and would basically revisit what I already said. I would rather comment on some specific aspects. One of them is this concept of transparency. There is no doubt that transparency is a value and can serve legitimate purposes. There are some but. The first one, and I already mentioned it, that transparency in itself is not a legitimate aim of restrictions of human rights. It's simply not mentioned in human rights instruments. So it's necessary to show that transparency serves one of the aims which are explicitly mentioned in this instrument. And to do that, it's necessary to make some evaluation. And using now the Georgian example, we were repeatedly told that, for instance, there was no evaluation made and no statistics, for instance, available as to any positive or negative impact of foreign financing specifically of these entities which are concerned by the legislation. And this is commonly the case. So as I mentioned, this is more presumed that there might be some harm done, but it's not based on any data. So transparency, yes, but the transparency needs to serve a purpose, and it needs to be established that it truly serves this purpose. That's one element. The second element, transparency needs to be balanced against other values, especially the protection of privacy. I mean, if we look into this room, you are all public figures, but I don't think you would like to have all information about your lives available to the public. You would not like to have 100% transparency, because there is certain information that you would like to keep for yourself that could even be dangerous for you. For instance, if all the information about your children, your families, are available online with all the private data. But that is exactly what some of the foreign agents legislation brings. Specific data, not necessarily about family members, but about people who are targeted. So transparency, yes, but it needs to be balanced against other values, because otherwise too much transparency can become a threat to the people. If everything is public, everything is available, it can be easily misused. I will stop here because I see we still have some questions.
Thank you, Ms. Bílková. Am I right in recollecting that the Georgian Parliament did pass the relevant legislation before the Venice Commission had actually issued its urgent opinion? Well, Mr. McAnally, please feel free to come back, but be fairly short this time. Thank you.
Thank you, Mr. Chairman. Yes, the review for the Venice Commission was not initiated by the Georgian Parliament. It was initiated by the monitoring committee, as well as by the president of the PACE. While it was initiated in a period when the discussions over the legislation have already started in the Parliament in accordance with the rules of procedure. And we have an experience, and Venice Commission representatives, they know about it very well, that when we are sending some document to the Venice Commission, we are preliminary announcing that, for instance, before it will enter the first hearing, it will be sent to the Venice Commission, or if it after adoption on the first hearing, we will send it to the Venice Commission, because the second hearing, you know, it's the most important, because you go to the details of every paragraph. When I had personally, because on behalf of the ruling party, I was communicating with the Venice Commission, and we had an online almost 2 hours communication on that matter. The law has already been adopted with the second hearing. But at that stage, we have agreed that the chance just to have Venice Commission recommendations presented to the Parliament for further consideration was via presidential veto. And the President preliminary has announced during the discussion period that she will definitely veto the law. Accordingly, I assume Ms. Bílková remembers that I have expressed this position that there is a chance, and it was accepted by the Venice Commission representatives, that so we have still chance that the recommendations will be presented to the Georgian Parliament. However, 2 or 3 days prior, before the Venice Commission opinion was published, President did not wait, and she vetoed the law without any explanation.
Right.
And the Parliament, in
Mr.
accordance...
Mr.
Yes.
McEnany, I don't think we need to delve too deeply into the details.
Yeah, I think it
of
was important just to
particular
explain. Thank you.
legislation, but thank you. Could I ask colleagues, we have further questions. Ms. Brama, thank you.
Thank you, Mr. Chair. I have 2 questions because of the discussion just ahead. Another question I raised. I think every one of us agrees on this, that we want to keep out the influence of authoritarian regimes from our own politics, and especially if it's not seen as such. But I think the conflict, which is in all of those anti-foreign agent laws, is that we're reluctant on naming this, and we just say we want foreign influence out, but we want authoritarian influence out, and we hesitate in naming that as such, and kind of reach out too wide and say foreign. So because of some diplomatic relations that we want to keep open, so that I think this is really a problem. But the other question that I have is for the laws in Russia, and it's been a very long time that it's already built on and on and on, and there is also a demand in the population to have organizations watching on human rights. So there must be a vacuum if there are no really human rights organizations. So my question is there are there so-called fake human rights organizations built in those countries, especially in Russia, and that are acting for the state? And how do people, or can you tell us, or do you have any experience with those, and how do people deal with that? Do they believe that they are human rights organizations, and how do they act in their daily life?
Thank you. We have a few moments left. Ms. Lokshina, could I ask you to respond to that? Thank you.
Yes, thank you very much for your question, Ms. Promo. So in Russia today, genuine human rights organizations, the leading ones in the country, were actually shut down. And they were shut down mainly over so-called incompliance with the foreign agents legislation, and that tells you a lot. Among those organizations are the true Russian human rights giants, like Memorial, like the Moscow-Helsinki group, which were actually awarded the European Parliament Sakharov Prize here in Strasbourg, right, quite a few years back. Also the Andrei Sakharov Center and Museum themselves. And the list of organizations which got shut down is already pretty long, but also some organizations actually had to shut down because they could not cope with the fines, they could not cope with the intrusive inspections, and they also could not deal with labeling themselves as foreign agents when they were genuine civil society representatives. Now, of course, in Russian society, there is a lot of demand for supporting people in protecting their rights and freedoms, but the government made it impossible for genuine human rights organizations to operate except in certain areas, like, say, the rights of people with disabilities, for example, the NGOs that work on this issue are not being targeted by the government. It's also possible to kind of quietly do some human rights work on the right of prisoners, for example, as long as we are not talking about high-profile political prisoner cases. But then the public monitoring commissions, the independent prison boards, however you want me to call them in English, which actually exist under Russian law, when they were introduced initially, they were made up of independent actors, representatives of human rights organizations, genuine civil society representatives, and now it's not the case. They were pretty much mopped up, and they do not carry out independent functions anymore. And what's very important is that no government official would speak to a foreign agent. Therefore, those NGOs that still remain on the ground, unless they are gongos, that is completely government-dependent, government-controlled, they can't even engage with the government, even at local level, which is, of course, very important. And lastly, I just want to get back to the opening point in Ms. Bílková's presentation. Foreign agent legislation, foreign influence legislation, whatever we call it, could be twofold. And if it's simply about transparency in foreign lobbying, like in the case of FARA, it's one thing. But if it's about any amount of foreign funding and so-called political activities, which in the Russian case include any sort of activities that could potentially influence the society and the government, then it's a totally different case. And they should not be put in the same basket. And the Russian government said time and time again that their piece of legislation, which is absolutely horrendous, and the Venice Commission also assessed the Russian law all those years ago, it has nothing to do with FARA. It is not even remotely similar to FARA. I'm not saying that FARA is a great law, but it's strictly about foreign lobbying. The Russian law is different. And the Georgian law, I'm not an expert on Georgia, but the Georgian law is different from FARA. It's not strictly about foreign lobbying. It's broader than that. So we are talking narrow, well-defined, necessary, and proportional. These are the key criteria.
Thank you so much. And could I now just thank both of our experts for what's been an extremely instructive address from each of them, and also thank colleagues for their contributions and my co-chair for her contribution. And at this point, I'm going to adjourn this meeting. With respect to the matter of the legal affairs, which is one half of this joint meeting, can I say that we will defer further consideration of other matters on the agenda until our next meeting. And that will be this afternoon at 2 o'clock. So thank you again, members.
Thank you.
Thank you.